two topics of contemporary relevance. The provisions of law. What is an arrest? What is the role of the police in arresting a person? What are the duties of the police in arresting such a person? How would the law differ? How would the scenario differ when it comes to arrests under the PTA? And also, after I finish my presentation of the PTA, I will be discussing with you the provisions of the ICCPR Act, which is a much spoken of and much talked of topic. Ladies and gentlemen, what is an arrest? Now, before I go to the question of arrest, now we all know that the freedom of an individual is a right that is generally respected through every constitution, every civilized legal system, and it is accepted as a fundamental right in most of the systems through their own constitutions. Now, if you look at our constitution, we have two constitutions to think of. The first Republican Constitution, enacted on the 22nd of May 1972, contained the concept of freedom of movement. Then the Constitution of 1978 further enhanced the constitutional right and the guarantee given to an individual relating to freedom of movement. What is this so-called freedom of movement? If you look at the provisions of the current Constitution, you will find the freedom guaranteed and protected under Article 14(1)(g). We all have the right to move freely in a free society. We all have the right to exercise the freedom that is guaranteed and protected under Article 14(1). But one thing that you have to remember is, even before the freedom of movement was constitutionally recognized in this country, our courts have jealously guarded the liberty of every individual. They have protected every citizen, every individual from arbitrary arrest. Now, is this freedom an absolute freedom? Does Article 14(1)(g) confer on you a freedom which is not questionable, which cannot be restricted, a freedom which is devoid of any control, restrictions, or limits? The answer is no. Even though there is a general concept, follow social media, I follow Facebook, and I love to see the younger generation talking about rights. None of them speak about duties. Everyone speaks of rights. They talk about, you have a right to move, you have the freedom of expression, which I will touch upon a little while later. Everything is a right for them. But remember, in law, I'm not going to bore any one of you with a 100% law lecture, because I bored 33 years of students when I used to teach at the law college. When you take the concept of a right, always remember, right and duty are two things which go together. They are synonymous with each other. When I have a right, that means somebody else has a duty towards me. So in other words, the right that we talk of under Article 14(1)(g) is not an absolute right. It is not an unfettered right. It is not 100% right, but it is a right that can be restricted. How do you restrict this right? If you look at the Constitution itself, ladies and gentlemen, you will find in Article 15 of the Constitution where restrictions could be imposed by law on the freedom that is conferred under Article 14(1)(g). Now, what are the instances where a freedom can be restricted? Based on national security, national economy, and public order. Those are the constitutional restrictions which are imposed through the Constitution in terms of Article 15 and specifically Article 15(7). At the same time, ladies and gentlemen, you ought to know that a man who claims the freedom given to him under Article 14(1)(g) can surrender that freedom by his own conduct, by reason of his own behavior, habit, or conduct. If you look at this slide, you will see the circumstances where an individual who is otherwise given a right under Article 14(1)(g), the freedom of movement, can curtail his right the moment he commits what in law is called an offense or a crime. Because the moment an offense or crime is committed, his direct involvement or indirect involvement opens out room for a criminal investigation to take place. That is the role of Mr. Ajit Rohana and his department to take over an investigation the moment a crime is reported. So there are two ways that limitations could be imposed on this all-important principle of freedom of movement. A, through the Constitution itself, Article 15, more specifically 15(7), and B, by your own conduct. Now, what happens there? You must remember, the moment a person is required by the police, I have to draw a difference here because I see some of the gentlemen from the army and the forces here. Army and the forces have no powers to arrest under the normal law. The power of arresting is given to two sets of people: the police and also private citizens can arrest and hand them over to the police. So therefore, what happens when a crime is committed and the crime is reported? You become a person who is wanted for the purpose of investigation. And ladies and gentlemen, the moment you become a person who is wanted for the purpose of an investigation, you become liable to be arrested. That is the normal law of arrest. What you see on this slide are the three requirements of valid arrest. That is, the arrest cannot be arbitrary. Mr. Ajit Rohana cannot arrest me because he doesn't like my face. There are a lot of people who don't like my face, but still for all, if they are in the police, they can't arrest me for that reason. That is an arbitrary arrest. Secondly, it must be done according to law, according to the procedure established by law, which I will refer to as I go on. And thirdly, the reasons for the arrest must be informed to the person who is arrested. So therefore, what is an arrest? How do you arrest? Ladies and gentlemen, under our law, I'm still talking on the general law of the country. Under our law, there are two situations where arrest could be effected. Firstly, if the alleged offense is a cognizable offense. A police officer has the right to arrest without a warrant. I remember long years ago, after a Royal BMICH, I had visited the house of a friend of mine, and his son had done something, and the police came looking for him. This young boy asked the police officer the question, do you have a warrant? To arrest that boy for what he has done, the police did not require a warrant. So when you are young, you ask for warrants. Remember, ladies and gentlemen, there are two types of arrests. First one is the cognizable offense, where you can arrest without a warrant. Second thing is the non-cognizable offense, where you require a warrant issued from a competent court of law to arrest a person. Now, how do you arrest a person? What is the law? I told you the right is freedom of movement 14(1)(g). An illegal arrest is constituted as reflected in Article 13(1) if a person is arbitrarily arrested, illegally arrested. The manner of arresting is set out in Section 23 of the Criminal Procedure Code. You have to actually touch the body of the person to be arrested and physically arrest him unless the person to be arrested submits himself to the custody of the police officer. So when the police tells you are under arrest, he has to touch you physically and then say you are under arrest. Mr. Rowan, I am right? Yes. Unless you agree to go with the police officer. That is a submission. Then you must actually touch the body of the person, that is the normal law, unless there is a submission to custody. And in terms of the 1979 Criminal Procedure Code, ladies and gentlemen, if you keep a person in confinement without actually touching him, or when there is no submission, you keep a person in a locked room so that his freedom of movement to get out of that place is removed, that is also an arrest. And the reasons will have to be informed. Now, when can you arrest without a warrant? You can't arrest without a warrant in every instance. The law specifies the circumstances under which a person could be arrested without a warrant. And what you see are the 4 situations where a person may be arrested without a warrant. Number 1, a person who commits a cognizable offense. So if I am the police officer, the first legal requirement is I must know that he has committed in my presence a cognizable offense. Cognizable means where you can arrest without a warrant. And secondly, if the police officer receives credible information, what is credible is a relative test. It will depend on the circumstances. I'll give you an example. Long years ago, Mr. Mahinda Wijayasekara, former member of parliament, was arrested on a telephone call given by Mr. Ronnie Dimel, the former Minister of Finance, who was the Minister of Finance of the J.R. Jayawardena government. I believe Mr. Fernando will remember that case. He was arrested on a phone call. It was argued on behalf of Mr. Mahinda Wijayasekara the arrest was wrong because there was no credible information. Then the Supreme Court said, no, how can you say that? The telephone call originated from a responsible member of the cabinet. Whether the Supreme Court is right or not, I leave it to you. There were other material on which the arrest was substantiated. Secondly, a reasonable complaint. Somebody has made a reasonable complaint against a person saying that he is the one who committed the offense, you can arrest without a warrant. In terms of section 23 and 32. And fourthly, a reasonable suspicion. I have underlined this, ladies and gentlemen. This becomes the most important aspect under the PTA and under the emergency regulations, because you are leaving the discretion of arresting a human being or an individual to the decision of a police officer or a member of the forces. So you can arrest a person if that person commits an offense in front of you, which is a cognizable offense, where you can be arrested without a warrant. If you receive credible information and that you have knowledge of that information, you can arrest him. A reasonable complaint has been made against a person, you can arrest him. Or a reasonable suspicion arises. A reasonable suspicion in the mind of the arresting officer. He must have reasons to suspect that he is involved in the commission or concerned in the commission of a cognizable offense. He must have material at the time of his arrest. And subsequently, if the arresting act is challenged, the courts will apply the objective test and see whether the facts warranted such an action on the part of the police. Whether the facts and circumstances justify the arresting officer to proceed to arrest is the question which arises in determining the legality or the validity of an arrest. So therefore, what happens? If a police officer arrests another without a warrant in respect of an offense where a warrant is required, that is an illegal arrest. If a police officer arrests another without a proper justification, that is an illegal arrest. If a police officer, having arrested the person, does not inform of the reasons of the arrest, that is an illegal arrest. What is an illegal arrest? Would amount to a violation of the fundamental right of every human being, which is protected and guaranteed by Article 13(1) of the Constitution. That is why whenever a person is wrongly arrested or claims that he has been wrongly arrested, he goes before the Supreme Court in terms of Article 17 and Article 126 of the Constitution. Now, why was the PTA introduced? Now, a fact which is less known to the current generation, users of social media and Facebook and WhatsApp and texting, is that Sri Lanka was under emergency from 1971, continuously, over a long period of time, until emergency was removed. 1971 insurrection, the emergency was promulgated in terms of Section 5 of the Public Security Ordinance, and thereafter we went through emergency. Most of you were born under emergency. You all are emergency cases. I was not born. I am a normal birth. Right? But most of you, I think Mr. Nawaz was also emergency. Yes, I know. Right? So, we lived through emergency. But the irony is, ladies and gentlemen, the general public of this country never realized that fact. They only hear about emergency when some TV channel or media announces about that fact. We all went through emergency. We were born, some of you were born under emergency, went through emergency, and then emergency was removed. For a very short period, in 2018, consequent to the Digana incidents which took place in Digana, emergency was reintroduced for a period of 2 weeks by the Parliament. And what happens is, in emergency, every month the Parliament has to vote that the emergency is to be extended. So they did not extend it. Then, how did the PTA come? Now we all know PTA came in 1978. It was introduced by the J.R. Jayawardena government. Why was it introduced? It was introduced for a reason. Because you all know there were certain incidents which were taking place in certain identified geographical locations in the country, and the government did not have any control. So the government felt that the ordinary law, what we have in the penal code and in other statutes, would not be sufficient to deal with that situation. So therefore, they had to come out with some law. And you will see that was the birth of what we call the PTA, or the Prevention of Terrorism Act. Originally, it was introduced as a temporary law, as a temporary mechanism. Now, if you look at the basis, which I have highlighted on the screen, it's very interesting. The basis you will find in the preamble. The PTA would have been given to you in the docket. Don't refer to it now. The preamble says men and institutions can remain free only when freedom is founded upon rule of law, and any change must be redressed by constitutional methods. You can't take to violence. You can't be hostile. You can't commit criminal acts in order to change a government or to come to power. Public order is endangered by elements and groups which advocate use of force and commission of violence by means of accomplishing governmental change. That was the focus. That was the basis on which the PTA was originally introduced as a temporary mechanism. Now, PTA is a special law, ladies and gentlemen, and it deals with offences which are different in nature to the ordinary law. Now, if you look at Section 2, death, kidnapping, abduction of a specified person. Now, who is the, now tell me a specified person here. Only Mr. Ajit Rowan is a specified person. Ah, yes, Mr. Nawawi. They are privileged category. Lawyers think bigger themselves, they are not specified. Specified person is the president, members of parliament, then gazetted officers, police officers, security personnel. The sun is shining a bit late. Come, right? And certain state council, members of the Attorney General's department. Yes. And accordingly, those categories of people were identified as specified persons. Death, kidnapping, abduction of a specified person was introduced as an offence. Death, kidnapping, abduction of an ordinary person falls under the penal code. Specified person goes to the PTA. Death, kidnapping, abduction of a witness to an offence under the PTA. I see somebody committing an offence under the PTA. You are the witness. I kill you, abduct you, or I will kidnap you. That's an offence. Intimidation of a witness, robbery of public property, mischief of public property, importation, manufacturing, collection of firearms and ammunition, possession without lawful authority any explosives within a security area. Security area is an area which is to be declared by the minister. Then, Mr. Fernando would recall 21H. 21H was a debatable section. Even as members of the Attorney General's department, we were members of the AG's department at that time. We used to argue about the rationale of 21H. Whoever, by oral words or visible signs, does something which will bring hostility among communities. We had our reservations about introducing, from a human rights point of view, from a human rights angle, whether 21H should have been introduced or not. Racial or religious disharmony, defacing or erasure of lettering, and harbors or conceals a proclaimed person. A proclaimed person is done by the IGP through a gazette. Now these are the punishments. I'll just browse through. Section 21A and B, life imprisonment, that is specified person. Section 2C to J, not less than 5 years, not exceeding 20 years. Section 3, offence of preparation, abetment, conspiracy of incitement. Now this is very useful. Section 5. If I come on television, I will be referring this question to Mr. Aditya. If I come on television and I say, I know that there is somebody who is involved in violence and terrorist activity. What have I done? I have failed to disclose that to the police. That is a Section 5 offence. If you have information pertaining to any act which fall within the realm or the ambit of the Prevention of Terrorism Act, and fail to report that to a police officer, fail to communicate that, convey that to a police officer, you commit an offence under Section 5 of the PTA, failure to disclose information. Knowing or having reasonable cause to believe that any person has committed an offence under the Act or is making preparation or attempting to commit an offence, having in his possession any information relating to the movements or whereabouts of any person who has committed such act, you become guilty of an offence under Section 5. Now, ladies and gentlemen, what is the effect of the PTA? PTA, as I said before, was introduced in 1978 because the J.R. Jayawardena government at that time had to deal with a lot of issues in the north and the east. Then they introduced the PTA with the expectation and in the hope that it will bring down acts of violence and hostility. Remember the preamble which I cited at the beginning? Then Section 2, Section 3, Section 4 and 5. Section 2, Section 4 and 5 of the PTA identifies the situations. What is the effect? Wider powers of arrest. We are dealing with arrest only. Now I told you normally a police officer can arrest. You can arrest in respect of a cognizable offence without a warrant. If the offence is non-cognizable, you require a warrant. You can arrest by touching the body of a person unless there is a submission to custody either by words or action. Even if there is no submission, even if you don't touch the body of a person, if you restrain the freedom of movement, keep him in close corners, that is also an arrest under the explanation of Section 23 of the 1979 Act. Right. Now, here we commence the discussion. Wider powers have been given to the police for arrest. Under the normal law, any peace officer can arrest. A police officer can arrest. Military can't arrest. Under the PTA, wider powers have been given for arrest and more than arrest, detention, which I will advert to in a little while. State has always argued that such powers are necessary. It was Sir Winston Churchill who once said that at times of war, the ordinary law goes down and you have to be mindful of that. I don't know whether Churchill is right or not, but be that as it may, one of the arguments that the state would always put forward is based on the Latin maxim which you see on the screen, salus civitatis suprema lex, which means security of the state is of paramount importance. When you are a nation, a sovereign nation, an independent nation, the government has a duty to protect the social order and the citizens and the society of that nation. That is based on the doctrine of public trust. Public trust demands, public trust requires the government to take all mechanism to protect its subjects and the citizens. So that is based on this Latin maxim called salus civitatis suprema lex. So on the one hand, you have a duty of protecting a nation. You have a duty of protecting the society. You have a duty to protect and maintain law and order, maintain national security, protect the lives of people. That is of paramount importance. That's a duty, a bounden duty on the part of state. On the other hand, so that's why I said state would always argue that such powers are necessary in times of emergency, in times which are not normal. Then, on the other hand, ladies and gentlemen, there is this allegation, it's a never-ending debate, that the laws are draconian, that suppresses the rights of people. Wider powers have been given to the authorities. Wider powers have been given to the forces and the army, Navy, Air Force, and the police. So therefore, on the one hand, you have the duty to protect the nation. On the other hand, you have to necessarily respect the individual rights of every human being. In every society, this is a debate which goes on and on, where it's like two railway tracks which will never meet. But how do we make them meet? I believe as professionals, it's our duty as a professional body to make them meet at some point of time. Now, what is alleged to be draconian, and I think Mr. Fernando, being the reasonable person that I known always, from 1982, very few occasions I can think where he was not reasonable. That's not in the public domain. Ladies and gentlemen, there were instances, you will recall, there were instances of abuse. There were allegations of abuse. We all know, we go by the maxim, or we go by the statement, power corrupts, absolute power corrupts absolutely. So, when powers, wide powers are granted, even for the purpose of maintaining law and order, even for the purpose of maintaining national security, even for the purpose of maintaining discipline and good order of a nation, there should not be abuses. That is what the court system is there for. It is the duty of our courts it would be the duty of our judges and our judicial system to be vibrant and interpret, maintaining a balance of both these aspects. So therefore, in the past, Mr. Fernando is well experienced in this. We used to work together, and I see Mr. Patinayaka. We used to work on many PTA matters when the PTA was in the stage of infancy. But it is extremely important that abusers, the room or the possibility of abusing is removed to the best possible extent. Now, as I go on, I'll relate one or two stories which happened to me in the aftermath of the 21st of April. One of the most brutal attacks which took place in this land. Now, how do you arrest under the PTA? An arrest under the PTA can only be made by a police officer not below the rank of SP. Or a police officer duly authorized by a police officer who is not below the rank of SP, but the person to whom authority is given to arrest must be not below the rank of a sub-inspector of police. So an SP or above can arrest, or an SI or above can arrest with specific authority from SP. The authority must be in writing. SP doesn't need authority to arrest, but the SI or the officer above would require authority to arrest in writing. They have wide powers. You can arrest a person, enter and search any premises, stop and search any individual or any vehicle, vessel, train or aircraft, seize any document or thing connected with, concerned in, or reasonably suspected of any unlawful activity. I have underlined 3 words there. Seize any document or thing connected with. Now, I am sure Mr. Ajit Rohan is going to have a lot of questions. I will also help in answering. Because now, yesterday I got a call, can the police take my phone into custody? Under the normal law, you can't. But if you are suspected of an offense, under this statute, you can. You can take a computer. Under the normal law, to take a computer, you need a particular order. But here, you can. Then, concerned in or reasonably suspected of any unlawful activity. What is this unlawful activity? Fortunately, the PTA came in 78. Otherwise, Mr. Fernando and I would have got caught under this definition. Not so unlawful, but mischievous activity. I always followed him. Unlawful activity means it's wider than what is in section 2. It is wider than what is in section 2 of the PTA. Any action taken or act committed by any means whatsoever, whether within or outside Sri Lanka. Now, there was a debate some time back. Some people used to say, if you commit something outside, there is nothing that you can do. Wrong. Section 2 and 3 of the Penal Code confirms that. This has been drafted in a particular manner. This is not our original draft. In Sri Lanka, generally nothing is original. This was a collation of a number of laws. And in that process, room was kept open to cover situations of unlawful activity extending beyond the borders. The definition of section 30, which is contained in section 31 of the PTA, would give an idea about what is unlawful activity. Then what do? Tonight, somebody comes and says, you had a lecture today. At that lecture, you said there is nothing original in Sri Lanka. Right? 21H. We suspect that you have committed an offense. They come and arrest me. So remember the rules. He must touch me. Or I must submit. Or he must put me into the room and lock me. Then he must tell me why he is taking me. Then I go. then going is no problem. A problem arises if you don't come back. That is the alleged abuse. That is the alleged abuse that the courts have jealously guarded over the last so many years from the time this law was enacted. That is the thing that we have to guard very protectively. Ladies and gentlemen, you arrest a person, normally under the normal law, you have to produce within 24 hours, or now extended time is given. But if you arrest under the PTA, you don't have to produce that suspect before a magistrate within 24 hours. You can keep that person in custody for a period not exceeding 72 hours. And thereafter, now for example, it's a very practical situation. He doesn't know who I am. I am taken into custody. He commences his investigation. I am under the PTA. He doesn't have to produce me within 24 hours. I am taken in. Then he realizes I am the head of a terrorist organization. You must respect the police fair duty. They are people who have to protect that concept called salus civitatis suprema lex. So therefore, I am taken in. He realizes after investigation, I am so and so. What does he do? He can ask for an order, a detention order, under section 9(1) for further detention. You will see in the next slide, ladies and gentlemen, if there is no detention order issued in respect of him, he must be produced before a magistrate before 72 hours. So I am arrested. I can be kept for 72 hours. No need to produce before a magistrate. If there is no detention order that the police would take on my behalf in respect of me, I will have to be produced in court before the expiration of 72 hours. The exception to the rule is, and ladies and gentlemen, by the way, these are laws. I told you there's nothing original about this law. We have got this from England and certain other European countries where terrorism acts were introduced. So, if within the 72-hour period the investigating police officer realizes that there is something more to investigate, he could ask and apply for a detention order in terms of section 9(1). When he is produced, if there's now say within 72 hours I am produced. If there is an application by a police officer not below the rank of a superintendent of police, the suspect can be remanded until the conclusion of the trial. I think I disturbed Mr. Nawawi early morning today and late last night over an issue. You take a person in, you have to produce him, you don't have to produce him in 24 hours, you keep him. Before the expiration of 72 hours, he has to be produced if there is no detention order. And when he is produced, if there is an application by Superintendent of Police or above, he can be remanded until the conclusion of the trial. Now, who gives him bail? Mr. Nawawi will give him bail, unless the Attorney General, Honorable Attorney General, decides to grant sanction. Then, after arresting a person under the PTA, that is what I told you a little while ago, the investigating officer can make an application to the Honorable Minister to issue a DO under section 9(1). If the detention order is issued within 72 hours under section 9(1), no need to produce before a magistrate. Now the minister can't blindly rubber stamp the application. At the beginning, when the law started, there were detention orders which were issued where the minister did not know whom he was detaining. Whether it's a suspect or somebody else, or even his own wife, he may not have known, he would have signed. That's the best thing that could have happened to a lot of people, but detention order is issued. I'm sure the ladies will also say the same thing to men. So I'm maintaining the balance. Now, ladies and gentlemen, you can't blindly endorse an application of the police to issue and sign a detention order. You must have reasons. You must be satisfied. And our courts have held on many occasions that unless the material furnished to the minister is satisfactory, that further detention is necessary, he is involved in the commission of an offence, further detention is necessary, you cannot issue a detention order. That can be questioned. Now, it's a very interesting thing. I use the word question. I will come to the next slide. Remember, detention order can be issued by the minister for 3 months. Extendable another 3 months. A total aggregate of 18 months is the period that a person can be held in detention. Anytime during the validity of the detention order, it can be suspended. An order of suspension can be revoked. There is provision under Section 9. Now, the detention order cannot be, I just told you a little while ago, a detention order cannot be questioned in a court. There are 2 exceptions. One is you can go by way of a fundamental rights application, but there you are actually going by Article 13.1 or 13.2. The substantive nature of the detention order will also come into light. And whether the detention is legal or not, the court can pronounce on. Then a habeas corpus application, Justice Kulatunga's judgment, not the present day Kulatunga, the previous Kulatunga. Honorable Justice Kulatunga, Supreme Court judge, his judgment, where he says that habeas corpus you can question. Then if a person surrenders to court, now this is a different scenario. Arrest under the PTA is under Section 6. This is a scenario where somebody surrenders to court or he is produced from another court. What happens? Then what happens is he shall be remanded until the conclusion of the trial, but the police can make an application, as I said in the second paragraph, through an SP or above, to have custody of that person for a period not exceeding 72 hours, what the court can authorize such decision. That is, I know that I am a person wanted under the PTA. What I do is I will retain Mr. Fernando if I can afford, and I will surrender myself. Then what has happened? The man, me, was never taken in by the police. They could not investigate me. They could not interrogate me. I go to the court directly. The court can give, on the application of an officer above the rank of SP, can detain him for a person, can permit to have access for a period not exceeding 72 hours. Right. Now, you basically, as far as the PTA is concerned, all what I want to say is, PTA gives wider powers of detention, a longer period of detention. The arresting procedure is different. Detaining period is much more longer than the normal detention one would expect under the normal law. At 2 points, the authorities have to be careful. At the arresting point, the arresting officer must be careful that he is wanted in respect of a PTA offence. At the point of issuing the detention order, the minister has to be careful, and there's no problem in Sri Lanka, all ministers are careful. They have to be careful that they are not, that the material furnished to them by the investigators require detention of those suspects. Now, having said that, මම වචන කීපයක් සිංහල භාෂාවෙන් කතා කරන්නම්. ත්‍රස්තවාදී වැළැක්වීමේ පනත 1979 අංක 48 දරන පනත ව්‍යවස්ථාදායක විසින් සම්මත කෙරුවේ එක්තරා විශේෂ අභිමතාර්ථයක් උඩ. ඒ අභිමතාර්ථය තමයි එවකට මේ රටේ උතුරු නැගෙනහිර පළාත්වල පැවතුණු ත්‍රස්තවාදය සම්බන්ධයෙන් ත්‍රස්තවාදී වශයෙන් අර්ථ නිරූපණය කරන්නට යෙදුණු කටයුතු සම්බන්ධයෙන් යම් ආකාරයක සාමාන්‍ය නීතියට වඩා වැඩි වාරණයක් ඇති කිරීමේ අරමුණෙන්. ත්‍රස්තවාදී වැළැක්වීමේ පනත සාමාන්‍ය නීතියට වඩා වෙනස්. මොකද ඒ පනත යටතේ සිරබාරට ගැනීම සම්බන්ධයෙන් සහ විශේෂයෙන්ම පුද්ගලයන්ව රඳවා තබා ගැනීම සම්බන්ධයෙන් වඩාත් පුළුල් බලතල අදාළ බලධාරීන්ට නීතියෙන් ලබා දීලා තියෙනවා. සාමාන්‍ය නීතිය යටතේ යම් කිසි පුද්ගලයෙක්ව අත්අඩංගුවට ගත්තොත් ඒ ගන්න අවශ්‍ය ක්‍රියාපරිපාටිය ආණ්ඩු ක්‍රමස්ථාවේ 13 ව්‍යවස්ථාවෙත් ඒ සමග කියවිය යුතු 1979 අංක 15 දරන අපරාධ නඩු විධාන සංග්‍රහ පන්ති 23 හා 32 වගන්තිවල දක්වලා තියෙනවා. ඒ අනුව කටයුතු කළ තමයි පොලිස් නිලධාරී මහත්මයෙකුට තමන්ගේ රාජකාරී කටයුතු වලදී යම්කිසි පුද්ගලයෙක්ව සිරබාරට ගැනීමේ හැකියාව තියෙනවා. ඒ සිරබාරට ගත්ත පුද්ගලයන් සම්බන්ධයෙන් කටයුතු කරන්නට ඕන ආකාරය අපරාධ නඩු විධාන සංග්‍රහ පන්ති 35 36 37 වගන්තිවල දක්වලා තියෙනවා. පැය 24ක කාල සීමාවක් තුළදී නිසි අධිකරණ බලය සහිත මහේස්ත්‍රාත්වරයෙකු ඉදිරිපිට ඒ තත්ත්ව පැමිණිය යුතුයි. එවැනි පුද්ගලයන්ට අපදීම සම්බන්ධයෙන් අදාළ වෙනවා 1997 අංක 30 දරන අප පනත. නමුත් ත්‍රස්තවාදයේ වැළැක්වීම සම්බන්ධයෙන් මේ නිර්මාණය වෙලා තියෙන 1979 අංක 48 දරන ත්‍රස්තවාදයේ වැළැක්වීමේ පනතේ ප්‍රතිපාදන ඊට වඩා වෙනස්. ඒ පනත යටතේ පුද්ගලයෙක් අත්අඩංගුවට පත් වෙන්න පුළුවන් වගන්ති දෙකක් යටතේ. 6 එක වගන්තිය 7 වෙනි වගන්තිය. 6 වෙනි වගන්තිය යටතේ යම්කිසි සැකකරුවෙක් එහෙම නැත්නම් ත්‍රස්තවාදයේ වැළැක්වීම පනත යටතේ වරදක් කරන පුද්ගලයෙක්. ඒ පනතේ වැරදි මොනවද කියන එක 2 3 4 5 කියන ප්‍රතිපාදනයට දක්වලා තියෙනවා. එවැනි වරදක් සම්බන්ධයෙන් තමා ඉදිරිපිට කරන පුද්ගලයෙක් හෝ ඒ වරදක් සම්බන්ධයෙන් credible information විශ්වසනීය තොරතුරක් reasonable complaint සාධාරණ පැමිණිල්ලක් or reasonable suspicion සාධාරණ සැකයක් තියෙන පුද්ගලයෙක්ව අත්අඩංගුවට ගන්න පුළුවන්. පොලිස් නිලධාරී මහත්මයෙකුට හැම කෙනෙකුටම බෑ ඒක කරන්න පුළුවන්. පොලිස් අධිකාරීවරයෙකුට වඩා ඉහළ නිලයක් දරන පුද්ගලයෙක්. correct? හෝ පොලිස් අධිකාරීවරයෙකුට වඩා ඉහළ නිලයක් දරන පුද්ගලයෙකු විසින් ලිඛිතව බලය පවරනු ලැබූ උප පොලිස් පරීක්ෂකවරයෙකුට වඩා ඉහළ නිලයක් දරන පුද්ගලයෙකුට. එතකොට මේ පුද්ගලයන් අත්අඩංගුවට ගැනීම සම්බන්ධයෙන් අපි දන්නවා සාමාන්‍ය නීතිය යටතේ පැය 24 කාල සීමාව තුළ ඉදිරිපත් කළ යුතුයි. නමුත් මේ වාරණය ඒ අවශ්‍යතාවය පැන නගින්නේ නැහැ ත්‍රස්තවාදයේ වැළැක්වීමේ පනත යටතේ අත්අඩංගුවට ගන්න පුද්ගලයෙකුට. එවැනි පුද්ගලයෙකු පැය 72 කාලයක් රඳවා තබා ගැනීම නීතියෙන් බලය දීලා තියෙනවා පනත යටතේ. ඒ 72 කාලය තුළදී පොලිස් නිලධාරී මහත්මයාට ආකාර දෙකකින් කටයුතු කරන්න පුළුවන්. පළවෙනි එක තමයි තවදුරටත් මේ තැනැත්තා විමර්ශන කටයුතුට අවශ්‍ය කියලා හැඟෙනවා නම් ඔහුට ඉල්ලීමක් කරන්න පුළුවන් ත්‍රස්තවාදයේ වැළැක්වීමේ පනතේ 9 වෙනි වගන්තිය යටතේ අදාළ ආරක්ෂක ඇමතිවරයාට රාජ්‍ය ආරක්ෂක ඇමතිවරයාට ඒ සම්බන්ධයෙන් ඔහුව රඳවා තබා ගැනීමේ නියෝගයක් නිකුත් කරන්නට කියනවා. ඒ රඳවා තබා ගැනීමේ නියෝගය මූලික වශයෙන් මාස 3ක කාලයකට වළංගු වෙනවා. හැබැයි මාස 3න් 3ට එම රඳවා තබා ගැනීමේ නියෝගය දික් කරන්න පුළුවන්, දීර්ඝ කරන්න පුළුවන්. ඒක උපරිමය මාස 18ක කාල සීමාවකට යටත් වෙනවා. එවැනි පුද්ගලයෙක් සම්බන්ධයෙන් අපදීමේ බල තියෙන නීතිපතිවරයාට ඒ තත්ත්වය දක්වලා තියෙනවා ත්‍රස්තවාදයේ වැළැක්වීමේ පනතේ 7 වෙනි වගන්තිය යටතේ. ඒක තමයි නීතිමය තත්ත්වයේ ත්‍රස්තවාදයේ වැළැක්වීම පනත සම්බන්ධයි. I will now move on to one of the most important and interesting topics, the ICCPR Act. Now, what is the objective of this act? Why was it passed? Mr. Tisattanayaka, on a statement that he made on the 23rd of December 2014. There were also several indictments which went out on certain other incidents on the ICCPR. Now we call it hate speech. What is this hate speech? When would my speech become hate speech? Those are the things that I believe more than any one of us, the learned gentlemen in the police will have to understand. That is the area that we have to educate. I'll tell you why. I told you in the earlier session when I was dealing with PTA that one of the most fundamental freedoms that our legal system and the judicial system has always jealously guarded is the liberty of an individual. What you find in Article 15(7), and if you subject yourself, the conduct of the human being concerned, if you conduct yourself in a manner where you have crossed the line and committed what is known as a criminal offense, that is by your own conduct. Now, what is ICCPR? I'm sorry to say this, but I have to say this. if you look at Facebook and the social media, there's a wild ass freedom. Made a complaint of defamation against Mr. Singha Ratnatunga. After the Sunday Times case, the criminal defamation went out of the book. So now, why do you need defamation? Why do you need defamation? Now, as a human being living in an orderly society, don't every one of you have a right to live peacefully? We all want peace. We want to mind our own business. We don't want problems. We don't want anything else but to maintain our dignity and live respectfully in the country. That is the country that we all dream of. When I was a young boy, I was also young once, a few years after Mr. Fernando, I had a dream. We all have dreams. When I was in school, we were taught that Sri Lanka was a developing country. When my children went to school in the 1990s, they were also taught that Sri Lanka is a developing country. When I encounter the young law students whom I taught for 33.5 years, they also tell me in the 2001st decade, they were taught that Sri Lanka was a developing country. Last Monday, my grandson started schooling, and he will be very soon taught that Sri Lanka is a developing country. Either we have developed to such an extent, none of us see that, or it is still developing. I believe the interpretation of the definition of the term developing has changed. Now, why do I say that? I firmly believe that Sri Lanka is a multi-ethnic country, at least for the last 700 years. That is a fact that one cannot deny. We are all one. We are all one, and if we are all one, we must live, and we must learn to live, either through the operation of law or through our own human conduct, as orderly citizens of a nation. Now, why was ICCPR? What happened? How did it start? How was it introduced? There's so much of hatred on Facebook. All communities. I am not identifying one single community. There are certain hate groups, or groups which decipher, which share messages in a language that I cannot read. Whether community A does it, B does it, C does it, or E does it. I said D, no? Right. A, B, C, D, E. Does it? It is wrong. The same rules must apply to everyone. There cannot be a difference. And also it is not right for any group or any community to claim sympathy. Because we have to live peacefully, we have to learn to respect each other. That is the bottom line. So having said that, what is this ICCPR? The General Assembly of the United Nations adopted the ICCPR on the 16th of December 1966. It came into force on the 23rd of March 1976. Sri Lanka acceded to the covenant on the 11th of June 1980. Now, I know a lot of people, they have spoken to me during the last 2 weeks about the ICCPR. So I asked them, do you know when it came? They don't know. They have found 4 letters of the alphabet, I, double C, P, R. Know nothing about ICCPR, know nothing about the concept behind it, know nothing about the history behind it, but claim rights under the ICCPR. So you first read and learn of what you want to know. Then, ladies and gentlemen, we became a signatory to we acceded to the covenant on the 11th of June 1980, and when you accede to a covenant, when you become a signatory to a covenant under the United Nations, there is a requirement. The requirement is you have to create your domestic law. You have to create your domestic law to suit the covenant. And what happened? Sri Lanka has had two constitutions, 1972, 1978. 1978 Constitution, in its chapter dealing with fundamental rights, identifies some of the rights already recognized under the ICCPR. So what the legislature, the Parliament of Sri Lanka, they had to pass a domestic law recognizing the other fundamental rights other than what is already recognized in 1978 Constitution, and that is the domestic law that they passed, that is the ICCPR 56 of 2007. This is the section that everyone is talking of. No person shall propagate war. If you look at the side note, actually I must confess, Mr. Nawawi, that this law has been very, very badly drafted. It is very, very badly drafted for a reason. Any law introducing fundamental rights which are not already recognized should first introduce the fundamental right. But here what do they say? No person shall propagate war. And if you look at the side note of that section, it speaks about propagating war. Of course, side note is not a part of the law, it's the draftsman's job. So no one can find fault with the 225 legislators we have. Right? So, no person shall propagate war or advocate national, racial, or religious hatred that constitutes, remember the word, this word I have underlined, incitement. Incitement to discrimination, hostility, or violence. Now, one of the things I must say is, in the Constitution we have the chapter dealing with fundamental rights. Any infringement of that fundamental right leads to a violation of that fundamental right. If the violation is by executive or administrative state action, then you can go under Article 17 and 126. But what is the provision if violation is by a private party? There was one case in the initial years of the 1978 Constitution, Perra versus People's Bank, 72 Constitution. Last case, it was argued by Dr. Colinaris, if I am not mistaken, for Perra versus People's Bank, 72 Constitution, last stages. Now, fundamental rights are fundamental rights. Fundamental rights, as long as they are violated by the state, you have a remedy. Article 17 and Article 126, you can go to the Supreme Court. Then the Supreme Court will pronounce the fundamental rights have been violated. But the concept of fundamental rights have grown beyond 1978. I always speak about rights. Remember, I pay more attention to duties. Right? We talk only about rights. No one talks about duties. There isn't a single non-governmental organization which speaks on duties, but millions on rights. Both are good. But having said that, what if a violation of your fundamental right takes place through a private party? Is it enforceable? Now these are issues. It is enforceable, probably by way of a civil action. But these are rights, these are things in the realm, in the awakening or reawakening on this concept of fundamental rights that we as a nation and they as a legislature must look at. No person shall propagate war. That is clearly understood. You can't propagate war. Mr. Liana Patabendiya can't propagate war. Both of them together can't propagate war. No one can propagate war. If you try to propagate war, you get caught anyway under the penal code 114, else 112, 114, etc. And you might, of the collective responsibilities there, then or national or advocate. I will come to the word advocate. It's not the advocate that we know. National, racial or religious hatred that constitutes incitement. That constitutes incitement. Every person who attempts to commit aids or abets commits an offense shall be guilty of an offense, and a person found guilty of committing an offense shall, on conviction by the High Court, be punished with rigorous imprisonment of term not exceeding 10 years. Not exceeding 10 years. Now, who decides, I will come to that, an offense under this section shall be cognizable and non-bailable. You can arrest without warrant. It is non-bailable. And no person suspected or accused of such an offense shall be enlarged on bail except by the High Court in exceptional circumstances. So, a magistrate can't give bail. There is a statement falling under section 3. You can be arrested without warrant. Magistrate cannot give you bail. You have to make an application to the High Court, and you have to prove exceptional circumstances. That is the law. And remember, once the matter is fixed to trial, the court is expected to give priority to the hearing of these cases. I have said in this slide that the side note is misleading. Now, when is this offense created? In the common sense, in the sense that we talk about, the society talks about, that we are concerned of. Social activists are concerned of. I am concerned of. Mr. Ajit Rowan is concerned of. We all are concerned of. Because the laws are good, laws can be tight, but there cannot be room for abuse. And if an abuse takes place, judicial proactivism will have to step in. Where a person propagates war, where a person advocates national, racial or religious hatred which constitutes incitement to what? Discrimination. If I don't give you a job because you belong to a different community, and I make an oral statement about it, you fall under section 3. And I'm coming to a very interesting thing that the police is having a different opinion, and I would like the Honorable Attorney General's representative, Ms. Navavi, also to look at this. If I make a statement in my workplace, I will not give a job to the Sinhalese, or the Tamil, or the Muslims, or a Burgher, or French. Why did I say French? Sri Lanka has a very rich history. You must know why. Have you heard of people who carry a surname called Bascom in Kandy? Their origin is French. Don't look at the social media and try to enter into open dialogue. History is important. You must know of what happened. Right. A person, I will not give you a job. I tell my CEO, I won't appoint Mr. Namavi as the Attorney General because he's a Muslim. Or Mr. Namavi tells Mr. Fernando, I'm not going to appoint Kalinga Indatissa as the Attorney General. I don't want to go there anyway, right? As the Attorney General, because he's a bad ethical fellow. Or a Tamil or a Burgher or whatever. What is that? That is section 3. Oral statement is enough. Because you advocates, what is the meaning of advocates? I'll come to the next slide, advocating. Then, what if you publish that? What if you publish that? That is also section 3. That is also section 3. What you say orally is section 3. What you publish is section 3. Then comes to the most important thing. Advocate. What is advocating? Unfortunately, the biggest issue, Mr. Ajit Rohana will agree with me, and this learned panel will agree with me, because there is no way that there is a definition. There is no definition of the term advocating. There is no definition of whether when a police officer arrests a person with a document, he has to decide whether that leads to a section 3 offense. There is no statutory definition. So in the absence of a statutory definition, you are looking at the discussion of an arresting officer. I'll tell you something which happened very interesting, and I'll wind up, because I know that you are bored. This is advocate means publicly recommend the support. Publicly recommend the support. Incitement. The action of provoking unlawful behavior, using someone not to behave unlawfully. Now these are things that the courts will have to look up and decide whether there is advocating, incitement. Because both these terms form part and parcel of the offense. When a person advocates national, racial, you must advocate national, racial or religious hatred, which constitutes incitement. Incitement to what? Incitement to go and see a movie? No. Incitement to go and see the World Cup, which is being drowned by rain? No. Incitement to discrimination. First example I gave you. Incitement to hostility. Go and kill the fellows, hammer the fellows. Incitement to violence. Then, a person guilty of an offence shall be punished without rigorous imprisonment for a term not exceeding 20 years. Offences are cognizable and unbailable. Bail is from the High Court, priority to be given to trials. Now, before this ICCPR came in, did we have sufficient laws? The answer is yes. To a particular extent, not a full yes, not a full no, to a particular extent, there were provisions. Penal Code section 290, injuring or defiling a place of worship with intent to insult the religion of any class, acts in relation to places of worship and with intent to insult the religion of any class, disturbing a religious assembly, uttering words with deliberate intent to wound religious feelings, deliberate and malicious acts intended to outrage religious feelings of any class by insulting its religion or religious beliefs. These offences were there. But the situation that we are envisaging today, and the situation that is going to become a menace to this society, was not fully covered by these sections. That is the problem that we had. So therefore, now oral statement, it becomes section 3. Written state publication, it becomes section 3. What about a post in the social media? Now social media is where everybody becomes a seasoned journalist. Right? ප්‍රවීණ මාධ්‍යවේදී වෙන අවස්ථාවක් තමයි. අපි ඉගෙන ගත්ත කාලේ නම් ප්‍රවීණ මාධ්‍යවේදී කියලා කිව්වේ අවුරුදු ගාණක් මාධ්‍යවේදය හදාarලා වාර්තාකරණය හරියට ඉගෙනගෙන වාර්තාකරණය සම්බන්ධයෙන් ග්‍රන්ථ කියවලා යම් කිසි තත්වයකට ආපු ප්‍රවීණ මාධ්‍යවේදියෝ. Today you have a mobile phone, you become a ප්‍රවීණ මාධ්‍යවේදියා because you are supplying material to Hiru, Derana, MTV, everybody same time and taking money for that. You are a ප්‍රවීණ මාධ්‍යවේදියා. මාණ්ඩලික වාර්තාකරුවෝ ඉන්නවා. ප්‍රාදේශීය වාර්තාකරුවෝ ඉන්නවා. හැමතැනම ඉන්නවා. But train them, because I'll tell you why, with all due respect. Media has a huge role to play in any nation. The role of the media is not to divide people. The role of the media is to bring people together in the context of a multi-ethnic society. I can talk to the media on media and the law subsequently. I am not on that. Media and Ethics of Journalism. Now, social media. You know, sorry to say this, I get up at 4 o'clock in the morning every day. Mr. Nalini Silla here, Mr. Shridivera and Commissioner Counsel and Navaratna, they know how to attend to things at the Bar Association. They get messages at 4 o'clock in the morning from me, SMSs and emails. They are sleeping, but they get up. Now, there are so many people in this country who have the time to create posts, publish them, share them, like them, comment on them, go to the substance and see what is there. It is meaningless. I used to use Facebook to educate my fraternity, which I still do. I talk to them on law, old stories that we knew, how to discipline yourself, likewise. But here, you go to the statements you will find, I don't know how people have time. For me, 24 hours is not enough. I really don't know why I became president of the Bar Association. That is your fault, you voted for me. But the reason is, what about a post in the social media? The police have a misconception, Mr. Ajit Rovana, that a publication in social media cannot be dealt with. That is wrong. I'll tell you why it's wrong. If I speak, and if my speech falls under Section 3, you can prosecute me, you know. You can prosecute me. Now they are recording me without my permission. You record me, my speech I make, that will be the mode of evidence, nothing else. Oral statement, Section 3. If I write, publication, Section 3. So what about a post in the wall for Facebook account? That is also publication. That is also publication. The only difference is method of proof. That is the only difference. So if you want to seriously curtail this hate speech, we can bring that under Act number 14 and 1995. Mr. Nawawi, we will bring it under Act number 14 and 19. You can bring it. There's nothing magical about it. Because this can be equated to the circumstances. When they record me, when they started recording me, and when Hiru started recording me a bit later, what are they doing? They are recording my speech. So where do I bring myself into a Section 3 offense? When I speak. What is that? That is the mode of proof. Who are these people? They are the witnesses to the fact that I spoke like that. That is additional proof. So, anything on Facebook, which is in electronic medium, can be dealt with in my view, and my view is generally not accepted. But in this instance, they have to accept it. In my view, that the posting on a wall of a Facebook is equal to publication. That is the manner of publication. And 14 and 1995 evidence special provisions will cover that. I think we should start filing test cases. It will be endorsed by the court at some point of time. So, ladies and gentlemen, I'm sorry to have bored you. This was not for you, that was for me. So thank you very much for giving me this opportunity to speak to you on two interesting topics. I hope you gain something. We are all in a learning process. The law is in the stage of infancy. I think collectively this country has to identify where we have made mistakes. And the Bar Association, in time to come, will play our role by the people of this nation. Thank you.